Good morning. Thank you for joining us this morning. My name is Annika Kisby and I'm an MD within the Real Estate Advisory Group within Kroll. My predominant focus is fixed charge receivership, although our team does also do secured lending for value for lenders as well. So we do a bit of everything, good book, bad book. But I suppose in this environment at the moment, the focus is more on the challenging properties and more of the bad book side. I know that our team is incredibly busy at the moment, so there is definitely an increase in distress in the market. And just looking at the land registry, we can see that from the data available, it states that the receivership appointments have increased by 83% in 2023 compared to 2022. And these are just formal appointments. So there is obviously more going on behind those. So with this increase in distress, we are speaking to a number of lenders who are really trying to understand what is the best course of action for their watch list. The increase in volume on this watch list means that they really need to understand what is the optimum strategy for recovery for these properties. I suppose what's interesting in this market compared to 2008 and the global financial crisis is that previously we dealt with just, the high street banks, maybe some Irish banks, and that was it. Now the landscape of lending has changed incredibly. So there are hundreds of lenders, and when they're looking at their books, their focus will vary depending on the size of their team, size of the firm, their structure, their funding lines, their sector exposure, and also just their level of experience of dealing with this kind of uncertainty in the market. The interest rates have gone up and values have fallen. So what is the best thing to do with the challenging assets that they have on their books? So really where this webinar has come from is looking to assist and advise on how to move forward with that watch list and help to advise on really what is the best course of action. Is it appoint receivers? We would always say yes to that, but often it's not. Or is it the fact that lenders should take possession themselves? Really, what is the best way to navigate that watch list? And also in this new environment with different regulations, new regulations such as breathing space, which Tristan's going to talk about, really what is the best course of action for lenders? So that's really going to be our focus today. I am going to pass on to Tristan Salter, who will help navigate and discuss all the different options for lenders in this challenging environment. Thank you, Tristan.
Thank you, Annika. My name is Tristan Salter. I'm a barrister at Five Paper. We're a set that specialises in commercial property and insolvency. So lending and secured lending is sort of our bread and butter, and it's a large part of my practice. And on the next slide, you will see some of the information that Annika was talking about in terms of the amount of increase in the market in terms of distressed lending and some of the background circumstances. So, and that is a factor that we've seen as well in our practice. I'm in court sort of 2-3 times a week, and you see the massive uptick in possession actions taking place across the sector, and in particular because of the challenging environment that it is right now. So on the next slide, I'm going to be telling you 3 things in the next 30 to 35 minutes. Firstly, I'm going to be looking at the options for enforcement after lending. I'm then going to describe to you and try to explain a bit about the court process and the timescales, because it's really important that you understand from someone who's in court all the time what is causing the delays and what are the problems in trying to get a property back if that is the option you choose. And thirdly, we're going to spend a bit of time talking about the Debt Respite Scheme, which is a new, essentially, scheme that was envisaged by the government and how that has affected the position for lenders. So on the next slide, I want to just highlight the current landscape. And this graph on the right-hand side of your screen is the possession activity in the county courts. Now, in relation to mortgages. Now, you will see that we are far away from the dizzying heights of 2008, 2009, where really there was a massive uptick in claims issued for possession of mortgage. However, you'll see from the right-hand side of that graph that things are starting to increase, and we are seeing a real uptick in actions against borrowers. And that comes from a very low point here from 2021, really, where essentially everything was stopped in the courts because of the coronavirus, and really nothing was going on. But what we've seen since then is a real steady increase, even despite the measures that the government has put in place, including the mortgage charter. So we are really facing a prospect of increased distressed debt, and we're looking at a situation where there is going to be more possession actions to take back properties from individuals. So on the next slide, we'll just also give you an introduction to the Debt Respite Scheme. This was a scheme introduced in 2021, and this was a scheme envisaged to provide a period of protection, essentially a moratorium on taking any action by anyone who was a creditor, and that will, in certain circumstances, include mortgage lenders. And it was for a period to enable a debtor to take advice. The reasons behind this are fairly complicated, but also because of our piecemeal system around debt advice. So at my last count, there are 5 different options that a debtor could go into in relation to debt advice. They could go from bankruptcy, debt relief orders, admin orders, IVA, or a debt management plan. And each of those options have different thresholds. And to the uninitiated and without a period of time to get advice, an individual might go into the wrong plan or the wrong program and actually be worse off. So unfortunately, I've seen people that go into bankruptcy situations when they simply didn't need to, and then there are additional costs and additional problems. Equally, it's not always the right option for creditors when a debtor goes into essentially an option that is not actually favourable to all parties. But the Debt Respite Scheme has proved particularly popular. In just 2 years, 130,000 people have accessed and used the scheme's protections, but it has also been beset by challenges, and that's partly because of the way it was drafted. It left a lot of sort of glaring holes and omissions in it, but also because there was a need to work out what the scheme was going to do and how it was actually going to operate. So there was always going to be some challenges via the courts. So that really is the background to the talk. And what I want to then move on to is the first part of this lecture, which is the options for enforcement. So to put it briefly, there are 2 main options for enforcement. Firstly, that a mortgagee takes possession proceedings themselves. Now, those on the call, you might be well aware of this, so I don't want to just teach you something you know already, but it's important to go over these points. So a mortgagee can take possession proceedings, and they have the power under statute or within the mortgage deed, and that is what happens a lot of the time, and a mortgagee would take possession. However, there are constraints on that power, and importantly, Section 36 of the Administration of Justice Act 70, and that essentially says that where a debtor is likely to be able, within a reasonable period, to pay any sums due, the court can adjourn the proceedings or suspend the possession on terms. Now, that's a really important power the court has because it can delay proceedings quite considerably. In the case that I mentioned there at Cheltenham and Gloucester Building Society versus Morgan, the reasonable period is the remaining term of the mortgage. So if you've got a long mortgage, then, well, the reasonable term is how that is going to be paid off over a small incremental amount. So what we see is, in practice, is that when we've got a possession action taking place, often we'll come across a borrower who comes to the first hearing come to the initial hearing, often they may not have had actually engaged with any of the process, which the mortgage company has said, we've sent you letters, we've tried to do all the things by the various rules and the pre-action protocol. They've said they've tried to engage as best they can, but the borrower simply hasn't engaged. They then turn up to the first hearing and they say, no, this is the situation. Oh, actually, I've got a sale of the property very imminent, or I can actually afford X, Y, or Z. Now, the court has a great reluctance to make a possession order out of the first hearing, and it's important that we have all that preliminary information. But there's a case called Global 100 versus Leleva, and what this does is essentially say that where there isn't a pleaded defence to the possession action, defendants should be given the chance to write out formally what their defence to the claim is. And given the wide nature of Section 36, an individual is always likely to be able to say something about their ability to pay, or, for instance, a sale of the property. We then also face these more, I'd say, speculative claims in relation to breaches of the various pre-action rules. And we also had a very strange uptick in the cases of fraud in relation to debts. And so people saying, well, that's simply not my signature on certain documents. Now, you would have thought that that would be given short shrift by judges, but it is a defence that is arguable. So we need to go through some motions to deal with that. But it's more common than you think, people saying this. So actually now we've got a sort of a process we go through by which we've got an expert where we say, look, here's a handwriting expert, we can look at signatures quite carefully. But it's one of the things about the records that does come up. In any event, there are periods of delay where a mortgagee can take possession. So those are the powers and unfortunately the constraints on those powers as well. The good thing is the final bullet point there is that subsequent adjournment should only really be given credence if there's new evidence. So if, for instance, a defendant comes and says, oh, I just need time to pay and I'm going to be getting this job on X date, it's not good enough for them to say at the next hearing, oh no, I'm going to be getting this job on X date. So it's important, I always find, to make sure that within the body of the order or recital, and this is something your legal team should be supporting you with, there's a clear rationale for why there has been an adjournment so that subsequent judges can see the reasons behind it, so that you don't get into problems where essentially the defendant's saying the same thing multiple times, be getting adjournment after adjournment. And that's a really important point just to highlight to those when you're instructing them. The second option for enforcement is on the next slide. And that's the appointment of an LPA receiver. Again, there is a contractual right or there is a right under statute to appoint a receiver. It is always best to appoint under the contractual right if it is there. That gives the receiver a far greater range of powers, essentially what's in the mortgage deed itself. But this will include possession, sale, creation of new leases if necessary, and the ability to take steps to get vacant possession. So that might mean getting tenants out of a property so that you can sell it vacant, which is always going to increase your options for sale and give you the best possible price, most likely. There is some quite recent case law on LPA receivers. And this case of Menon v. Pask, it was, I think it's a 2020 case, it's not that old. And essentially it was all about LPA receivers and actually what their sort of rights are to take possession action because of the way the agency rules work in terms of LPA receivers. So it was a really interesting case. If you want to dig deep into how and why LPA receivers can be appointed, that's a case to look up, and you can look up essentially the various rules about agency there. The simple point is that an LPA receiver can take possession in their own name. They are also constrained by Section 36, but there is obviously some actions they can take before they seek possession as well, for instance, and getting rid of sitting tenants. And unfortunately for some, and probably Annika in this said, their remuneration is capped by statutes as well. So those are your two main rule areas of enforcement for lending. And they, on the next slide, I'll just go through some of the issues with both of them. But the main point is that each of them are trying to get the best possible price for sale. So essentially you're trying to maximize the sale value. And it's often thought that time should be given to borrowers to sell the property on their own. And that's because it is likely not to be it is likely to achieve a better price because it doesn't look like a distressed sale. And essentially the other side who are purchasing the property can't take advantage of that. But that comes with real caveats, and the courts are very slow to say that, oh, we'll give you time as a borrower to sell the property unless you've taken some real concrete steps. So I would expect to see someone saying, well, look, the estate agents have come round already, they've done the photos and it's up on Rightmove. A nod to estate agents, if they want to sell properties right now, they will be round that day to take photos. They are having an interesting time in the market and no one's probably crying over lawyers or estate agents at the moment, but they will come round and sell your property in a heartbeat if they want to, or judging by the number of communications I get from Foxtons, and I'm not even trying to sell a property at the moment at all, they just keep on emailing me, they will do it. In relation to the mortgagee and the receivers, they also have a duty to get the best possible price, and you can understand that. You can't just sell the property so that your debts are covered and leave nothing for the individual. That would clearly be wrong. The mortgage company is likely to take valuation evidence about that or put it up in relation to a couple of estate agents. Receivers, a bit more broader in scope. They can look at expert valuation advice. They can look at other aspects of selling properties in portfolio, for instance. And so where you have someone who has a number of properties, LPA receivers can be quite useful in the sense that they can look at different options, i.e. are we going to group them in particular classes, particular assets, and sell them all as a group and try and achieve the best possible price, or are we going to go do it individually and sort of how that's going to work with the costs of each sale as well. So there really are different options. They both have good success rates, but the next slide might give you some pause for thought on both options. So I put up the number 728, and in the course of the research for this lecture, I came across this number, and 728 is the average number of days it takes a possession action from first inception to order at the moment. It is taking 728 days, or 2 years basically, to get from a claim being issued to an order in the court. Now, partly that's to do with some issues in relation to the mortgage charter and some delays in the court, but it is very clear that the court system as it is in its entirety is slowing down. I've been doing this job for a decade now. It is quite obvious that in that decade, the system is just taking longer and longer to get a single case from X point to Y point. It is almost ridiculous, but also it's stopping legislation. So you would have probably heard in the news that the Conservatives had a planned commitment to abolish what they call no-fault evictions or Section 21 notices. Now, they introduced that plan, I think, in about 2018, 2019. Now, there was a delay to the coronavirus, but they've recently said, no, we're not going to do that until we can fix the court system and make the court system smoother, because the big worry was that no one was going to actually be able to get possession of their properties back, and the whole buy-to-let sort of rental market was going to collapse because the court system was so slow. So it really is a long endeavour. So that is something to think about as well. On the next slide is some of the hoops that the mortgage companies have to go through. You've obviously got the mortgage charter. I'm probably speaking to those that know all about the mortgage charter, but essentially it's to increase the amount of support to borrowers, and it's to say that unless there are exceptional circumstances, a mortgage lender will not take possession within a year of the first default. Now, personally, that's probably a bit of an empty promise, because if you are getting possession within a year of the first default, you've probably done pretty well in the court system at the moment in time. It is just that slow. So maybe it was a mortgage charter promise that everyone really could sign up to, because it doesn't actually mean that much. Now, that's my skeptical look at the world, but that's just my approach to the court proceedings. You obviously have the MCOB rules and essentially the higher level of interaction you have to have with the borrower. Now, again, it's not uncommon for a borrower to not engage with the process right the way up until we get to the door of the court. But it's a hugely important process. Having that information and support is really useful from my point of view as a barrister going to court on the day, because we can say, look, we've tried all of these steps and there's been no engagement. So to the borrower, you have to come up with something really concrete now because we've tried. Again, there's a pre-action protocol and you will know that. But essentially it's about providing people with advice, help, tips, support, assistance and guidance to try and get them to the court process. So there's one other thing I want to talk about just before I move on to the Debt Respite Scheme. And this is on the next slide. And this is the question of reasonable adjustments under the Equality Act. Now, this is a fairly niche part of the law, and I only raise it now so that you all have an awareness rather than a sort of deep understanding of it, because it's something that crops up every now and then. But essentially, under the Equality Act 2020, a disabled person can make a request for a change to either a physical thing or a practice or procedure. Now, this is most obviously thought about in the way that, for instance, high street banks make certain adaptations to their branches. So, for instance, in installing ramps or in putting in hearing loops, that's all because of reasonable adjustments under the Equality Act. Now, I think I've lost the slides, but I'll carry on. The current position is that some challenges have been made to essentially say that mortgage companies have to make reasonable adjustments to change the nature of their lending. So in a case at Green versus Southern Pacific Mortgages, an individual who's disabled said, I want you to make a reasonable adjustment from changing my mortgage to a sort of full repayment mortgage to interest only. Now, the courts have said, no, that's not a reasonable adjustment because that's a change in the nature of lending. That's a different product. But it's important that you are aware that these requests come in. If something like that does come in, it's to try and flag up this slide, and then you do need to seek probably some legal advice about this very discrete point, but it's important not to ignore it. It's not going to probably make a huge difference, but I always flag these things because they come up sort of 1 in 1,000, but if they come across your desk, it's really important that you have a sort of ping of recognition that you've heard this at some point in the past and go, I know something about that. I've got to dig out these slides and ask the questions. In a nutshell, it's a request you have to take seriously, but it doesn't have to change the whole way you do lending as well. So that's an overview of the court process. There are many challenges. Most of them are procedural. But what I wanted to then talk about in detail in the sort of final 15 to 20 minutes is the Debt Respite Scheme. So on the next slide, hopefully comes up, we have the Debt Respite Scheme. So as I said before, the Debt Respite Scheme was introduced in May 2021. It was to provide a breathing space for those in financial difficulties and to encourage them to seek advice and assistance and to ensure that those in mental health crisis are given some protection. Essentially, it's a moratorium on actions to enable people to seek advice and support where they need it. They said the debt product landscape has become increasingly confusing, and it is fragmented as well. There's not one single procedure. Now, what I want to do now is explain some of the Debt Respite Scheme. It's a fairly strange scheme in its setup, so bear with me. But if there are any questions afterwards, just please let me know. So, first of all, you might think, oh, what is a debt that qualifies for this breathing space? Now, the definition is in and itself confusing. So, a qualifying debt is anything that is not a non-eligible debt. So it's a sort of double negative to try and confuse everyone. But essentially, it means that all debts that are covered unless you can find an exception. Now, there are some obvious exceptions that, for instance, if you are making child support payments or fines to certain government bodies, you have to pay those debts regardless. Secured debts in the context of ordinary lending are also non-eligible debts, so they are not covered. However, the arrears of those debts are covered by the scheme. So the arrears that an individual is in are covered by the Debt Respite Scheme. That might seem strange, but that is just how the language of the regulations work. So if you have arrears or any other form of debt, which is not a secured debt, you are going to be covered by the scheme. And there are some quite important effects. So there are 3 effects that I put on the next slide. There are serious restrictions on a lender, including about contact and about actions. So first of all, you cannot require a debtor to pay interest that accrues on a moratorium debt. So you can't say that an individual accrues, from a lending perspective, any interest in relation to their arrears, in relation to when they are in a breathing space. You can't get around that interest by saying it's a fee or penalty. Again, you can't ask them to pay any fees or penalties in relation to the debt that accrued during a moratorium period. And finally, you can't take any enforcement action against a moratorium debt during that period, or there are some exceptions in relation to the fact that the court can grant relief in relation to that. So those are the effects, and they are quite stringent. And on the next slide, very simply, it's if you take any of these actions during the moratorium period, they are null and void. Any step taken in breach of the regulations is null and void. Okay, so that's really important. And in one of the cases that we'll talk about later, that actually involved the unpicking of a sale to an unconnected third party, because that whole process, that whole enforcement process, and then sale to another individual was declared null and void. So the action took place, and then that had to be unpicked. So that's really important. And the courts have dedicated email addresses and are looking at whether or not someone is in a debt respite scheme. Now, on the next slide is what you can do or you must do. So in relation to qualifying debts, they are essentially qualified at a certain point in time. So when someone enters into that scheme, that's essentially day 1 or day 0. Anything that falls apart falls due after that is not a qualifying debt. So the debtor has to pay its ongoing liabilities. What a creditor can do is contact a debtor about those ongoing liabilities. But the regulations are very, very clear that a creditor must not make contact in respect of a moratorium debt. So you can't send chasing emails or letters or have a process which sends out an automatic chase or letter for those moratorium debts, including those arrears those arrears, debts that are qualifying debts. So that's really important, because if those steps are null and void and you're then trying to rely on them later for pre-action protocol processes, they essentially haven't taken place and you will be in breach of the regulations. Now, the regulations do allow a creditor or a lender to answer questions and queries that come from the debtor, but you're going to have to be careful about how you phrase those. You're going to have to answer those questions without attempting or being seen to attempt to chase a debt up in any format. What you must also do is, if you know someone is going into one of these schemes, you must inform the court as well. Now, you don't have to, in my view, inform the court if no action is going to take place during the period of time that someone's in a debt respite scheme. But for instance, if you know they're in a scheme and you've got a hearing in the next day or so, you're going to have to inform them about the fact that someone is going into that scheme. And that's really important, because, again, all of the actions can then be unpicked if you have gone down a line of enforcement without being aware. There are scenarios where you can say to the court, well, no, look, we have to take action going forward for certain tasks, but it's going to be very rare, and the court is going to be very hesitant to sanction any actions, including progressing the case in essentially any way, shape or form. So that's going to be very difficult, and you must inform the court. Now, you may already know, and I haven't touched on it yet, that there are two versions of the debt respite scheme. There is the breathing space standard and the breathing space mental health. Now, they are different because of the dual purpose of this regulation. And as we go back to that original quote, it was about giving people a chance to get advice and assistance, but also ensuring that those that are suffering from mental health issues are given a period of protection. And it's important that the wording was never looking at that people with mental health issues were going to get advice. So I'm going to talk to you now about the two different versions of the breathing space scheme. So on the next slide, we have the breathing space standard scheme. So everyone and anyone is eligible to enter a breathing space standard scheme, as I call it. They last for 60 days and you can use it once a year. Now, it's really important that you understand that it can be used once a year, but also that joint debts are covered. So there are two really interesting cases in relation to this point. The first one is Axonola versus Break. That was essentially the first case that came out about the debt respite scheme. And I'll just give you some brief facts about this. And essentially involved, I can't remember how many high court hearings there are between these parties, but essentially it's ongoing litigation where Mr. and Mrs. Break essentially try every single tactic under the sun to try and stop this debt being collected. So the Mr. Break entered into a mental health moratorium, and I'll come back to that in a second, on the 6th of May 2021. Anyone with a keen eye to this scheme, that is just 2 days after this scheme came into effect. Okay, so they were looking at the legislation and seeing what they could do. And there was very, very little evidence about what mental health issue Mr. Break was suffering from at that point. Again, I'll come on to that. The important point was that even though the debt was jointly owned by Mr. and Mrs. Break, no action could take place against either of them because it was a jointly owned debt. This came to a head in a probably even more egregious case of West 1 versus Sahil. Now, this is probably even more egregious in an attempt to use the breathing space scheme to essentially frustrate a process. So the facts, very briefly, in relation to this, is that there was a 12-month loan back in 2015 for some 4 million, and there was action, which culminated in an order by 2018 and a possession order. And there was an eviction scheduled for the 24th of November 2021. Now, what took place then is what seemed to be a tactical use of the breathing space scheme. So just one day before the eviction was due to be scheduled, the first defendant went into a breathing space standard scheme, and therefore they got protection from eviction for 60 days. Just as soon as that one finished, the fourth defendant went into a breathing space moratorium for another 60 days. So in total, they'd had 120 days worth of protection. Now, you could probably see the logical outcome of this is that essentially each of the individuals in turn could go into a breathing space moratorium, and then there would be a very long wait for enforcement action. Yes, they can only use it once a year, but you don't need that many jointly owned defendants to essentially frustrate a process for a whole year, and then you're getting back round to the start again. So luckily it wouldn't happen with just 4, because you only get to 240 days, but then you only have 110 days to get your possession action in, and knowing the courts, that's unlikely to happen. So there was a challenge to that, and I'll come on to the challenges in a bit, but essentially it was said that the fourth defendant's breathing space moratorium was unfair, and an injunction was applied. And I will come back to the issue of injunction, but it just shows the strength of the arguments, because one argument that was defeated was that only one breathing space moratorium is allowed per debt. And no, the court said it's an individual right, so each person is allowed a breathing space moratorium. It's about the person, not about the debt. So important to know when you're dealing with multiple defendants. Moving now on to mental health moratoriums, and I realise that I'm running out of time rapidly. These are even more interesting and potentially a space for greater lender confusion and need to get serious legal advice. Because breathing space standard lasts for 60 days. As I said, the court system's fairly slow anyway, so they might disrupt one enforcement action, but it's unlikely to be a long-term problem. Breathing space in relation to mental health is actually much wider in its application. So it lasts 30 days after the crisis care has finished. So as long as someone's in crisis care, and that could be years, months, decades, they are covered by the breathing space protections. It can be used whenever someone is in mental health crisis. That's particularly important for individuals where their mental health might fluctuate. You can see some mental health illnesses like bipolar disease or schizophrenia might fluctuate over time. So for instance, someone might be in and out of acute crisis care. Again, joint debts are covered. So for instance, if it's me and a partner or me and a friend, and they go into a mental health breathing space, well, my debt in relation to them is also covered. So you can see it can have quite a wide application. Now, the first point on the next slide is important, is that what constitutes essentially a mental health crisis. Now, this was the subject of a case called Kane and Lees. And essentially, the court took a look at what the regulations under Regulation 28 meant, because the first set of regulations, I think A to D, are ones you would expect, ones that where essentially someone has been sectioned or detained by the police under a mental health ground. Section E in the regulation says that you are in the community and the debtor is suffering from a mental disorder of a serious nature, and in respect to that disorder, the debtor is receiving crisis, emergency, or acute care. Now, the problem with the regulations as they were drafted was essentially a mental disorder of a serious nature is quite a woolly definition. Lots of mental disorders are serious. I'd say probably all of them are serious. And lots of people are in a state of crisis. in relation to that. So there's too many words there that essentially are unable to be defined. So what we saw in the Axona and Break case is that someone with essentially, well, it turned out to be not very clear, but it wasn't very clear if someone with, for instance, anxiety or depression who was receiving treatment from their GP would qualify under this definition because they were in the community, but they had a mental disorder. You could argue it's serious for any individual, and they were receiving care. But Kane and Leeds, a 2023 case, paid to some of that. What the court said in that case was, okay, you have to look at that community care in respect of what the other definitions are under Regulation 28. So the other definitions under Regulation 28 are about being detained by the police, so forcibly being detained. So it's of such a serious nature that you are going to be detained by the police or by a mental health professional. So that's the sort of yardstick that we should judge this community care by. But it still leaves it open to some interpretation, and there will be some people who are receiving quite high level mental health care in the community that will be serious. So it's important to think about it from that point of view. It is unlikely to cover what I might say is less serious mental health issues, such as anxiety or depression, for instance, or even including other mental health disorders such as dementia, because again, you're not being detained in the same way, but you would never say that that is not a serious issue. So it, however, does leave ambiguity, which isn't fantastic for those trying to deal with the scheme. So on the next slide, I very quickly detailed the cases in relation to how the courts have tried to define the mental health aspect of this breathing space scheme. Very quickly as well, and these slides will be available to you, so I think you'll be able to deal with it. On the next slide, I highlight that you can challenge a breathing space. You can challenge a breathing space for two reasons. Either there's been unfair prejudice, or there's material irregularity in the making of such an order. Now, two things to say about those words. They're quite normal words to those that are in the insolvency profession. These are words that we turn up all the time. I always like the phrase unfair prejudice because it is there a awareness that there will be prejudice. So that's the starting point. That prejudice has to be unfair. So you're already not going to get, for instance, as many toys as someone else. That's unfair. But is that unfairness prejudicial? So you've got to think of it like that as we run up to Christmas. Okay, and I've got to get presents for my nieces and nephews. They're going to get different presents, but is it unfair? No, my 11-year-old niece is much more interesting than the 3-year-old nephew. She gets more presents. That's fine. The other way of thinking about this is material irregularity. Now, material irregularity is the way that you might challenge someone's decision about whether or not someone is in a mental health crisis. Because essentially, does that serious threshold, has that serious threshold been met, or is there been a material irregularity in the making of that decision? So those are your avenues for challenge. As I said on the slide, it's only likely to be worth it in relation to mental health moratoriums because breathing spaces last such a short time. In the West 1 and Sahil case, obviously, by the time they got to court, actually the breathing space had dissipated. Now, West 1 were continuing the action quite sensibly because there was a risk that more and more people started doing these actions. So, first of all, you can make a request to the debt advisor. All these breathing spaces are signed off by a debt advisor, and you can make a request to challenge one of these breathing spaces and whether your debtor is included in that to the debt advisor. It must be made within 20 days and the review must be completed within 35. So that is a short period of time, but you can see then you probably already used up half of your standard time already. So you might just grin and bear it in respect to that. If the breathing space is not cancelled by the debt advisor, on the next slide, I've just highlighted that you can also make an application to court to challenge it on one of those two grounds, unfair prejudice or material irregularity. Okay, and as I highlighted at the bottom there, if there is a reason to believe the debtor is not receiving mental health crisis treatment, that might be a material irregularity. So that's very important to be aware of. So, and coming to the end of it, I just wanted to highlight the court's approach in a couple of different cases. So I've already talked about Axola versus Brake, and that is about joint debtors. It is also a case which highlights that future debts are not covered. So it is essentially when someone enters into a debt respite scheme, that's, as I said, day zero. Any ongoing liabilities do need to be paid and they're not covered by the debt respite scheme. So for instance, you may want to say, well, actually the arrears that take place later are not being covered and action can be taken on those if it's a particular discrete point. West One Loan Limited versus Sahil, as I said, is important because it is all about joint debtors. It makes it clear that each debtor can apply for a breathing space and you can't really do much about it. But if there seems to be action which is concerted and attempting to frustrate the system, you may be able to say that that is unfairly prejudicial to your interests, especially if you've got 7 or 8 debtors, joint debtors. You can see that a year period could pass and then the whole cycle start around again. So you may want to challenge in respect to that. Now, finally, K and Lees. Now, there are, I think, 4 or 5 different cases with K and Lees. This is the very latest one, and the quotes there. It is different from the one I just highlighted earlier, and this is the latest one in relation to the debt respite scheme. This is really an interesting big one because what it highlighted not only is the question of unfair prejudice and that dual definition that it has to be both prejudicial and unfair that I like to highlight. It also highlights a feature that the courts potentially slipped into and probably slipped into error in doing. So both in West One Loan and in an earlier version of the K and Lees case, the courts attempted by a restrictive injunction to say, no, you debtor, you cannot apply for another breathing space or a mental health moratorium for the next X period of days or months or years. And the courts looked at that and said, no, sorry, it's not right to grant injunctive relief, but in the most exceptional circumstances, because Parliament gave to each individual debtor a right to apply for either a breathing space once a year or for a mental health moratorium whenever they were in acute crisis care. So that's very important in respect of the breathing spaces. But overall, the courts have been willing to accept challenges to breathing spaces, and they have constrained the avenues for mental health moratoriums taking effect, which is a useful clarification because the drafting of the Act was not as potentially good as it could be. So in summary and in some conclusions, on the next slide, these regulations have teeth. Failure to comply can have really serious consequences because those steps will be counted as null and void. Actions and applications to cancel moratoriums and breathing space moratoriums are likely to be common, especially when there's no evidence that a debtor is seeking debt recovery options or where there's joint debts. That's not the same in relation to mental health moratoriums because a person in a mental health moratorium is under no perceived obligation to go attempt to get help for their debt problems. It's an attempt to give them mental health time. In the short term, it can cause delays with enforcement, and it's important that those are taken on board. And very importantly, joint debtors are protected, and that has, as we've seen, caused real problems. So that is a brief run through of the Debt Respite Scheme. If there are, on the next slide, any questions that you want to raise, please either ask them now or feel free to email me or Annika about them, and I can answer any queries that you have about the Debt Respite Scheme and how it's operating from a practical point of view.
Thank you, Tristan. It's slightly mind-blowing, the whole 728 days with the courts. I hadn't realised it was quite that long. Yeah, crazy.
Well, so at the start of last year, there was an obligation on the court to give you an initial hearing within 8 weeks, or that kind of time, and they got away with that regulation and just kept it open-ended and with a target of something. But we've seen first hearings, almost 3-4 months later after issue, and that's sometimes if it doesn't get lost in a paperwork bundle in, for instance, Central London County Court, which is, I don't know, a law unto itself. So if there are,
sorry, slight delay on my part there. Kind of with all these kind of regulation, it's all well and good, but in a falling market, that as values are falling, the longer it takes, or the more more action there is, you're actually putting often borrowers in a worse position, aren't you? It's interesting.
Yeah, and you've seen that as the market slowed down, but everyone's trying to hold on for an uptick, which no one can give any certainty about, or predictions are coming out every other week, but it seems to be a slowly falling market, only propped up by lack of demand. So yes, you're right, there's a lot of avenue for saying this isn't helping individuals. Unfortunately, they're probably not getting the right advice that they need right now, which is, this is becoming unaffordable and you shouldn't hold on to this asset because you're going to be in a worse position. But you'll have seen it a lot with people with mortgages at 2% and now 6 or plus, and that having because it was so low for so long, people just didn't see the risks involved in that position. So that's where I see it. We've definitely seen a massive uptick in the amount of mortgage possession and also second charge possession actions. That's where we see a huge growth, especially relatively old debts that were accruing quite a lot of interest. People were quite happy, but now obviously it's coming to the point where actually the debt's ballooned and the potential equity in the property is only going one way.
Yeah, absolutely. All right, well, thank you very much, and thank you everyone else for joining us today. We hope you found it helpful. As Tristan said, the slides and the recording of the webinar will be shared for anyone who would like it. Yeah, please don't hesitate to contact us if you have any questions or points to discuss further. We'd love to hear from you. Okay, thank you very much. Bye-bye. Have a good day.
Thank you.